Hello everybody again. So on this rather gloomy day in London, I'm here to talk to you about international arbitration and in particular to provide an introduction to some of its key features and principles. I just wanted to let you know that this is a webinar in a series, so there will be a follow-up webinar being held on the 27th of June, which will provide a practical perspective on arbitration. So just to give you a general outline of what I will be discussing today, just in case you want to log off now, I will cover the following points. Firstly, I will set out what is arbitration. Then I'll look at some of the key features of arbitration. Then I'll come on to discuss the advantages and disadvantages of arbitration over litigation, and discuss why the parties may want to arbitrate their disputes. Then I'll conclude with how to arbitrate, including explaining the key points of an arbitration agreement. And finally concluding with some final remarks. So to kick off, what is arbitration? It is generally defined as an alternative dispute resolution method that is based on the parties' agreement and provides a final and binding decision. It is an alternative dispute resolution method, or ADR as it is commonly known, because it is alternative to litigation in the courts. There are many other forms of ADR. However, the main difference between these forms and arbitration proceedings is that it produces a final and binding decision, where most other forms of ADR do not. So coming on to looking at other key features of arbitration. Firstly, the right to arbitrate a dispute is based on a contractual agreement to arbitrate between the parties. This can be set out in either a standalone agreement or more commonly in a clause of a wider agreement referred to as the arbitration agreement. This is a key difference to litigation through the courts, which does not need to be based on any contractual agreement. Arbitration is therefore a voluntary and consensual process, and the tribunal will only have jurisdiction over the dispute if all the parties have agreed to submit that dispute to arbitration. This can cause, however, some difficulties when joining third parties to arbitration proceedings who are not party to the arbitration agreement itself. In order to join them, it would be necessary to obtain the third party's agreement to arbitrate the dispute. Another key feature of arbitration is that it can provide a neutral forum for resolving a dispute. As it becomes increasingly commonplace for parties to contract with parties overseas and for parties to work on projects abroad, there is a need for a neutral environment for resolving disputes. Arbitration can go somewhere to putting the parties on a level playing field, especially in circumstances where you are not in a position to negotiate with overseas clients regarding the choice of governing law. For this reason, arbitration is often the preferred method of dispute resolution for cross-border disputes. Arbitration also provides the parties with the ability to choose the fundamental aspects of the proceedings, including the location of the arbitration, referred to as the seat of arbitration, the language, procedure, and the parties can importantly select the arbitrator itself, or can determine how that arbitrator is appointed. Arbitration is also particularly beneficial to parties who want to keep their disputes private, as arbitration proceedings are generally confidential. The parties can agree for all the information provided in respect of the arbitration proceedings to be private, or can decide that certain aspects of the arbitration are private. For example, you can just choose that the hearing and the arbitrator's decision, referred to as the award, is only private. This is a key difference to litigation which is held in public. Arbitration, as I've touched on previously provides a final and binding decision. And arbitration proceedings will only allow for appeals in very limited circumstances, which can provide finality to arbitration awards and can avoid the time and expense of dealing with lengthy appeals. Finally, another feature of arbitration is that provided a country is a contracting state of the New York Convention, the contracting state is obliged to recognise and enforce foreign arbitration awards as binding, save for in very limited circumstances, such as if it is determined that the agreement to arbitrate was not valid, or the award goes further than the scope of arbitration. Okay, so now we've looked at some of the key features of arbitration. What are the advantages and disadvantages of arbitration in comparison to litigation, for example? Arbitration provides flexibility. As we've said, the parties are free to choose the location, language, procedure, and importantly, the decision maker of the dispute, the arbitrator. Litigation in comparison is generally a very rigid process, which is determined by the legal system of the location of the dispute, and the appointment of the judge is decided by the courts. Another key advantage is that arbitration allows the parties to pick a tribunal which has specific expertise in the field of dispute. As the parties are able to choose the arbitrator themselves, for particularly technical disputes, for example, they can choose someone with particular expertise in the specific discipline. This can be very useful as the arbitrator will have a good understanding of the technical issues at hand. In comparison, in litigation, the parties have no say whatsoever in the appointment of the judge, and they may not have any technical knowledge in the field of dispute. Arbitration proceedings can also be an advantage because they are confidential. This is a key advantage if the parties want to keep the dispute out of the public eye. The parties to litigation do not have any such luxury, and the information that arises on the dispute will all be public. Another advantage that we've touched on previously is that arbitration can provide a neutral forum for parties to resolve their disputes. The seat, procedure, and appointed arbitrators can be completely different to where the parties are based or the location of the project. Arbitration is also generally accepted to be a quicker process than litigation through the courts. However, there is some thinking now that this may no longer be the case, and the length of the arbitration will depend on a number of factors, including how many arbitrators are appointed and their availability. As you can imagine, trying to coordinate multiple busy arbitrators' diaries can be very difficult. Another advantage is that it used to be anyway considered to be cheaper than arbitration. However, this is not always the case and will also depend on the particular circumstances of the case. However, the parties will have more say in the procedural process and can try and keep costs down in that way. As explained just now, arbitration provides for a final and binding decision, and so there's very limited ability to appeal awards unless there have been particularly serious procedural irregularities or jurisdictional issues. So this can be seen as an advantage because it provides finality to awards, and it can potentially avoid the expense of lengthy appeals. In comparison, in litigation, the parties are able to appeal on wider points of law. A foreign arbitration award can be enforced in any contracting state of the New York Convention, provided the conditions of the convention are met, which is also another advantage, because in litigation, foreign judgments may be enforceable, but this will depend on whether the jurisdiction has reciprocal agreements with the contracting state where the judgment was made. So having looked at the possible advantages of arbitration over litigation, we'll now look at some of the disadvantages. In arbitration, provided that it has been determined that there is a valid arbitration agreement, the parties will waive their rights under the contract to resolve their disputes through the courts. It may not be known at the time that you enter into the arbitration agreement, and not until the dispute arises, whether arbitration or litigation would be the preferred dispute resolution mechanism. However, by the time that the dispute occurs, it will be too late, as you've already signed up to the arbitration agreement. Another possible disadvantage is in arbitration, the parties themselves will have to pay for the arbitrator's fees, which can be very expensive. In comparison, judges' fees in litigation are not paid by the parties. Whilst the limited ability to appeal may be considered as an advantage to some who want finality in respect of the dispute decision, it can also be a disadvantage to others who don't agree with an arbitration award and want a chance to appeal the decision. However, parties to an arbitration will generally be prevented from appealing. Also, in arbitration, the disclosure of documents is likely to be more limited, which may be an advantage from a cost perspective, or if you have documents which you do not want to disclose. However, it may also be a disadvantage if certain documents are not disclosed, which could have helped support your case. Interim remedies, such as an award for security of costs, may also be more difficult to obtain in arbitration in comparison to litigation, depending on the jurisdiction of the court, and may be more difficult to enforce. As explained before, in arbitration proceedings, it will not be possible to join third parties to the proceedings unless they sign up to an arbitration agreement. Therefore, further separate proceedings may need to be made to join or to include the third party, which may increase costs. In litigation, in comparison, third parties can easily be joined relatively commonly, full stop. Arbitration awards are not directly enforceable themselves, but a party must resort to judicial remedies to enforce, which is more difficult in comparison to, say, a court judgment in litigation. So now that we've looked at the advantages and disadvantages of arbitration, it's also helpful in deciding whether to choose arbitration, whether to look at these questions and ask yourself these questions by looking at the advantages and disadvantages. So the following questions may help you. So firstly, are disputes that are likely to arise on the project likely to be cross-party? i.e., is the project or the party you are contracting with based abroad? If so, arbitration may be a good option for you and may be easier to negotiate than litigation in your own jurisdiction. It is also sensible to consider what the alternatives are. If you are contracting with a client who will only accept litigation as a dispute resolution method, if it is in their own, say, foreign unknown jurisdiction, it may be sensible to try and agree to submit disputes to arbitration. You should also ask yourself whether disputes are likely to be particularly sensitive. If so, arbitration may be more appropriate to keep information out of the public eye. Another question to ask yourself is, are potential disputes on the project likely to be particularly technical in nature? If yes, then it can be advantageous to agree arbitration in order to appoint a specialist decision maker with experience in the technical field of the dispute. Do you want flexibility in the resolution proceedings, or would you prefer a more rigid process? If flexibility is preferred, arbitration as opposed to litigation would be more appropriate. If there is any possibility that the legal entity you are contracting with may become impecunious, for example, you are contracting with a shell company or SPV with limited assets, it may become necessary, if a dispute arises, to apply for interim remedies such as security for costs. In these circumstances, it may be better to agree litigation because interim remedies are more difficult to obtain, as already discussed in arbitration. So, if the parties have decided that they would like to arbitrate and to include arbitration as a dispute resolution method, then the first stage is for the party to sign up to a valid arbitration agreement. The arbitration agreement governs the rights and obligations of the parties in the arbitration. It is therefore important that the parties negotiate an arbitration agreement which best serves both parties' interests. This can be in the form of a separate agreement or more commonly a clause within a wider agreement. It is often the case that little consideration is made to the drafting of the dispute resolution provisions in a contract because people are more interested in other clauses. However, the importance of clear, unambiguous drafting of the arbitration agreement cannot be underestimated. There are obvious difficulties with drafting an arbitration agreement before a dispute has arisen, as the parties will be unaware of what the dispute is when drafting the agreement, and it may be difficult to foresee what the parties want at this early stage. However, the arbitration agreement should try to put the parties in the best position possible should a dispute arise, and therefore the drafting should be clear and comprehensive. If there is any ambiguity in the drafting at all, it could give rise to jurisdictional challenges or satellite disputes, which can be very expensive and distract from getting on with resolving the dispute in question. A common mistake I have seen is where there are conflicting clauses provided in the contract. For example, the dispute resolution clause of the agreement may provide for arbitration as the method for resolving disputes. However, elsewhere in the contract, in the governing law clause, it may stipulate that the parties submit to the exclusive jurisdiction of the English courts. This should be avoided, obviously, and careful consideration should be given to the drafting so that the agreement clearly provides for arbitration. You should include the following key points when drafting an arbitration agreement. The party should include whether the arbitration should apply to all disputes under a contract or any specific disputes. Certain disputes may be dealt with better in litigation or other ADR mechanisms. The parties should include the number of arbitrators to be appointed. It is common for the arbitration agreement to provide for a sole arbitrator or a panel of 3 arbitrators, where one arbitrator is chosen by each party and the third arbitrator, who acts as the chairman, is nominated by the arbitration institution adopted in the arbitration agreement. The arbitration clause should set out whether the parties want the appointed arbitrator or arbitrators, if there's more than one, to have experience in a specific discipline. For example, it could be set out that the arbitrators are specialists in the subject matter of the dispute. The arbitration agreement should also set out how the arbitrator is to be appointed. for example, by agreement between the parties or nominated by a specific body or third person. The seat of the arbitration, the language of the arbitration, and the governing law of the arbitration should also be set out in the arbitration agreement. In addition, the arbitration agreement should set out whether the disputes will be resolved by institutional or ad hoc arbitration. If the parties choose ad hoc arbitration, no institution will be adopted. If the parties choose institutional arbitration, the parties will need to set out a particular institution that will administer the arbitration proceedings. There are a number of arbitration institutions with varying different procedural rules, which we'll come on to later. Or now, actually. So here are a few examples of the key arbitration centres around the world. It's not all of them, because it was not possible to include a full list within this talk. But key ones are the International Chamber of Commerce, the ICC, the London Court of International Arbitration, Singapore International Arbitration Centre, the Dubai International Arbitration Centre, etc. Just to let you know that further consideration of things to consider when drafting an arbitration agreement and the benefits of the different arbitration institutions will be discussed in our later webinar in this series on the 27th of June. So, now that there is a valid arbitration agreement and a dispute has arisen between the parties, how should the parties go about appointing the arbitrator, or tribunal as it's referred to? So firstly, the parties should check the arbitration agreement which they've agreed to, as the appointment of the arbitrator will be governed by what the parties have agreed in that agreement. In the event that the arbitration agreement does not specify how the tribunal will be appointed, the selection of the arbitrator will be in accordance with the relevant procedural rules agreed if institutional arbitration is adopted. In ad hoc arbitration, where no institution is adopted, a state court or an appointing authority can assist in the appointment of the arbitrator, or the parties can simply reach agreement as to the appointment at the time the dispute has arisen. It is also common for parties to ad hoc arbitration to rely on rules such as UCITRAL rules, which can provide procedural rules for the appointment of the arbitrator. So now turning to the tribunal's powers under the arbitration proceedings. The powers of the arbitrator or arbitrators are determined by, firstly, what the parties have agreed in the arbitration agreement, and secondly, the applicable procedural rules. If the arbitration agreement and procedural rules do not cover a particular procedural topic or do not provide procedural rules at all, the applicable procedural law of the governing law of the agreement will apply. For example, in England, Wales, and Northern Ireland, the procedural rules of the Arbitration Act 1996 will apply. So now turning on to arbitration fees. It is common in arbitration for the parties to be required to pay an initial upfront fee to cover the arbitration fees and arbitration expenses. For example, in ICC arbitrations, the claimant will be required to pay to the ICC an upfront non-refundable filing fee to file the request for arbitration, and also a provisional advance of the cost of the arbitration until the terms of reference are drafted. Both parties will then be required to pay equal contributions to an advance on costs to cover the costs of the arbitration to get to the final hearing, which is fixed from the value of the claim and any counterclaims. The ICC will fix the actual cost of the arbitration at the end of the proceedings, which will be paid from the advance on costs. If there are any leftover amounts, these will be reimbursed to the parties. Under other procedural rules, the arbitration fees may be calculated by reference to the time spent by the tribunal on the dispute. It's also worth bearing in mind if the arbitration is being administered by an institution, a fee will also be payable to the institution for administering the proceedings. So turning now to the procedure of the arbitration. The procedure of the arbitration will be governed by the appointed the institution in the arbitration agreement. However, if no institution is adopted, for example in ad hoc arbitrations, the parties can draw up all the procedural rules themselves, although these may be difficult to negotiate, so they may require the arbitrator to determine the procedural rules or adopt specific rules for ad hoc arbitrations such as the sectoral rules. The procedural rules will vary depending on the arbitration institution's rules adopted, but generally provide a framework for the proceedings to get to the decision, i.e. the award. They usually cover the constitution of the tribunal, the commencement of the arbitration, provision of evidence, the hearing, the award, and costs. So we're now at the end of the arbitration proceedings, and the tribunal will issue the award, i.e. the equivalent to a court judgment. The award will usually be required to be signed by all the arbitrators and the parties themselves. Some procedural rules impose a time limit for the tribunal to issue the award. For example, the ICC imposes a 6-month deadline from the date of the last signature to the terms of reference. The parties themselves can also agree in the arbitration agreement for time limits for the issue of the award. However, this can cause difficulties if an award cannot be delivered in the agreed deadline, and it may frustrate the parties' agreement to arbitrate the dispute. So just some concluding remarks to end with. Here is a quote from Lord Langdate in 1843, voicing his opinion that the parties' interests may be better satisfied in arbitration than by litigation. So there we have it. It was a quick run through of my introduction to international arbitration. If you have any questions on this webinar or anything in connection with it, please do contact me and I'll get back to you with my views. And just a reminder that the next webinar in this series will be held on the 27th of June, which will provide a discussion on a practical perspective of arbitration. So please sign up to this. It won't be me, so the voices will change. So thanks very much. Cheers.